Hi, this is the business guy. So how do you put assets into a trust? And here's the big reason this is important. Having a trust does little good unless it actually holds the assets it is meant to protect or the assets you intend to transfer to your loved ones after your passing. I've personally drafted thousands of trusts over the past 33 years I've been in this business. In order for a trust to work, you have to put your stuff into the trust, and when you finish watching this video, you're going to know exactly how to do that. Funding a trust means that your assets are actually transferred to the trust and are officially owned by the trust/trustee so that the trust can function as you intended it to do. So first, we'll talk about how to title the assets properly on the document. We'll talk about how to transfer real estate, such as your personal residence, into a trust, bank accounts, vehicles, and personal property, such as jewelry, antiques, and things that don't have titles. Next, we'll talk about things you cannot put into a trust. And then, what about the items that you forgot to put into a trust? What happens to those? We'll tell you. And then we'll end with a story so you'll really understand why this is important. It is a story of a wealthy couple who didn't put their assets into the trust and a nightmare scenario that it created for them and their children. So click like, subscribe if you haven't already, and let's go. And if you want to set up a trust or have questions, visit us at assetprotectionplanners.com and fill out a consultation form. Changing ownership to a trust. When you transfer assets to a trust, you are changing the legal ownership of the assets. In most cases, you transfer the assets from your name to that of the trust. Now, most people who have us create a living trust name themselves as both the trustees and the initial beneficiaries of the trust. So you'll still generally be able to use the assets, but the trust/trustee will hold the assets for you. So here are the steps, and the law makes me tell you this isn't legal advice, just helpful info, and to seek an attorney before doing any of this. Step one, to get started, you want to make a complete list of the assets you want to transfer so that you are sure that you don't leave anything out. Now you've made your list. Step two, put your assets into the trust. Now there are two categories: assets with titles, like a house, car, or bank account, and then you have assets without titles, such as jewelry, art, and precious metals. For things with titles, you change the title. For things without titles, you make a list that describes those things on a piece of paper called a schedule that is referred to in the trust and that you attach to the trust. Here's how. Now, things with titles. For a house, you'll usually use a grant deed. With a grant deed, there is a grantor. Memory hack, where the "or" at the end is the original owner within this transaction, the one transferring the property. And then there is the grantee, the one receiving the property. To remember this, the grantee is where you want it to be. In this case, you want it to be in the trust. So if you own the house now and your names are John and Mary Smith, you in this case are the grantor. You list your names separately: John Smith and Mary Smith, grantors. It is important to look at the current deed and see how you're listed on it and list yourself in the exact same way as the grantor. Then the grantee is where you want it to be. Now, when you put property into a trust, you need to write both the name of the trust and the name of the trustee on the title. You can name the trust first or the trustees first. The order really doesn't matter in most cases. I like to name the trust first because for privacy purposes, because some public records displays only hold so many characters, and the name of the trustee may not be so easy to find online. So here's some examples of how to hold title. The John and Mary Smith Revocable Living Trust, John Smith and Mary Smith trustees, Fred Williams and Sally Williams, trustees of the Fred and Sally Williams Revocable Living Trust. Now, we set up land trusts for privacy, so we'll often set up a Wyoming LLC to serve as the trustee so you have extra privacy, and title a property like this: 123 Main Street Trust, comma, ABC Holdings LLC, parentheses, Wyoming, trustee. Notice in all cases we named both the trust and the trustee and clearly stated that the person or company is holding the asset in his or her capacity as trustee and not individually. So we mentioned a grant deed. What type of deed should you use to transfer real estate into a trust? One of the most valuable assets most people own is their home. You can transfer your home, or any real estate for that matter, to a trust with a deed, a document that transfers ownership to the trust. A quitclaim deed is one of the simplest methods and one of the most commonly used between related parties, such as a person and his or her living trust. trust. So if you don't care about the trust protecting your privacy, the quitclaim deed is a good choice. Alternatively, a grant deed, and especially a warranty deed, ensures that you have good title when you transfer it and may make it easier for your trust beneficiaries to sell the home down the line. So you can check with an attorney about which type of deed is best in your situation. A few states like North Carolina require that all deeds be prepared by attorneys, so you may not have a self-service option. Okay, now step number 3. Once the deed form is prepared, a real estate deed must be filed with the county recorder's office in the county where the property is located, and you'll need to pay a filing fee. In most counties, the fee is very reasonable, like $25 to $150, but there are over 3,000 counties in the U.S., so check locally. Now, a deed transfer into a trust should not affect your mortgage, even if you have a due on sale clause provision. The Garn-St. Germain Depository Institutions Act of 1982 says that you can transfer 1 to 4 dwelling units into an inter vivos trust, such as the living trust and land trust that we create, and the bank cannot by law call the loan due. So this is a single family home, duplex, triplex, or fourplex that people actually live in. The owner of that house, that is the mortgage holder, must be a beneficiary of the trust. And you should inform your homeowner insurance company just so that they are aware that you have transferred the title into the trust. So that is step number 4. Once the deed is transferred, you may need to change your homeowner's insurance to indicate that the trust is the owner of the property. Step 5. If you receive a real estate tax exemption, you'll want to make sure that it is properly applied by showing documentation of the trust to the taxing authority, such as a certificate of trust, a document your attorney can create that certifies the existence of the trust. Okay, so those are the steps to transfer real estate into a trust. Transferring bank accounts to a trust. To transfer assets such as investments, bank accounts, or stock to your trust, you'll need to contact the institution and complete a form. You will likely need to provide a certificate of trust as well, then sit back, relax, and let them do the rest. You may want to put your personal checking account and savings account into the trust as well. Transferring vehicles to a trust. Each state is different, but you'll usually need to contact the DMV. You'll also call your insurance company to be certain they will continue coverage once the transfer is made. We set up a lot of title holding trusts for vehicles so people can own their cars privately, and then we'll often set up a Wyoming LLC to serve as the trustee because of the privacy, as well as the protection and the low cost of setting up a Wyoming LLC. So to transfer ownership, you will need to obtain a title change form from your DMV and complete it, naming the trustee as the trustee of your trust as the new owner along with the name of the trust. Now, sales tax should not apply to the transfer, and if the clerk tries to apply it, you'll need to speak to a supervisor. Now, if you own a boat, you'll usually need to follow a similar procedure to transfer title. If it's a Coast Guard registered vessel, you'll contact the Coast Guard's National Vessel Documentation Center. Okay, now things without titles. Transferring personal property to a trust. You likely own many things that don't have actual written titles or ownership documents, such as jewelry, furniture, collectibles, and the miscellaneous things that fill your home. To place them into your trust, you can name them in your trust document on a property schedule, basically a list that you attach to the trust document that is referred to in the trust document, and indicate their ownership is being transferred to the trust. Now, first, you need to name the schedule. If it is the first schedule attached to the trust, you might call it Schedule A. Then you write a list of the stuff you're putting on the schedule. Then in the trust document itself, you'll need to say, "See attached Schedule A." Now, keep in mind, this is only for things without titles. If it does have a title, you need to change the title. Putting things with titles on the schedule without also changing the title to that asset isn't putting that asset into the trust. Now, if any of these items are insured, be sure to contact the insurance company to transfer the insurance to the name of the trust as well. So what items cannot be placed in a trust? Now, there are some things that cannot or should not be placed in your trust. Individual retirement accounts or IRAs cannot be owned by a trust. So these must remain in your own name. But you can contact your IRA custodian and name the trust as the primary or secondary beneficiary. Trusts are often named as beneficiaries of life insurance policies. It's a good idea to talk to an accountant to understand any tax implications of doing so. Okay, now what about things that you forgot to put into the trust? Let's say you purchase or inherit items after you create the trust. You'll probably want to transfer those items to the trust ASAP. If possible, right when you acquire the items. Purchase them as trustee of the trust so they are automatically placed in your trust. And another thing you can do is consider a pour-over will. So to further protect yourself, you want a pour-over will. When we set up a living trust for our clients, our in-house attorney generally also creates a last will and testament, which will indicate that any items left in your name are transferred to your trust upon death, so that your trust will be complete and provide all the benefits you created it for. Now keep in mind that a trust is merely a contract that can be drafted however the person who wrote it wants it to arrange the words on the page. They're trusts for estate planning, so that when you die, those you care about get your assets. They're trusts that can protect assets from lawsuits, protect your privacy, or care for the needs of future generations. In order to take advantage of these advantages, you'll need to properly put the assets into the trust. So as promised, here's a story. So you're motivated to do what we just talked about. It's important to know why. I know of no better way to do this than with a story. So here's a story about the bad things that can happen if you have a trust, but you don't put your stuff into it. Imagine this. Jane and her husband Tom had worked their whole lives to build a comfortable life. They owned a beautiful home, had a couple of rental properties, a solid bank account, and even a few valuable family heirlooms. Wanting to protect their assets and make things easier for their two kids, Jane and Tom did what they thought was the responsible thing. They created a living trust. They figured they were set. Their kids would avoid the hassle of probate, and everything would be seamlessly transferred to them when the time came. But here's the tragic twist. Jane and Tom never funded the trust. They never transferred their home, bank accounts, or properties into it. The trust existed, but it was just an empty shell. And to make matters worse, Tom unexpectedly passed away in a car accident, leaving Jane devastated. She thought the trust would take care of everything, but it didn't. A few years later, Jane passed away too. Their children, Amy and David, were grief-stricken, but confident that at least their parents' careful planning would mean they could avoid legal headaches. After all, there was a trust, right? Well, not so fast. When Amy and David went to their parents' attorney, they were hit with a shock. None of the assets were inside the trust. The house, the bank accounts, the rental properties, everything was still in Jane and Tom's name. Instead of a smooth transition, the family was thrown into a legal nightmare. Welcome to the probate court. For the next 2 years, Amy and David found themselves trapped in an endless maze of paperwork, court hearings, and legal fees. They had to hire probate lawyers who charged hefty fees, sometimes a percentage of the estate's value, just to navigate the process. Each asset had to be evaluated, appraised, and properly accounted for. Then they had assets in other states, and they had to hire an attorney in that state as well. For the house and rental properties, instead of immediately transferring to Amy and David, they were tied up for months in legal wrangling. And it wasn't just about the money for the legal battles. Though it was bad enough, the emotional toll was just as painful. Amy and David had to sit through court hearings discussing their deceased parents' finances in front of strangers. Their family's personal matters became a public spectacle. There was the added stress of family tension too. Amy and David had differing opinions on how to manage the estate and its mounting legal bills. At one point, they even considered selling one of their rental properties just to cover the probate costs. The trust their parents thought would protect their legacy instead turned into a source of frustration, anxiety, and resentment. And what's worse, because of the probate process, it took over 2 years for Amy and David to get full access to their inheritance. During that time, some assets lost value, bills piled up, and valuable family heirlooms were mishandled. People broke into the rental properties and destroyed things. The once well-intentioned plan Jane and Tom had made to ease their children's burden had become a nightmare. What went wrong? Quite simply, Jane and Tom didn't understand that having a living trust isn't enough. You have to fund it without transferring their assets into the trust. Everything they worked so hard for was left vulnerable to the legal system, and all of the trust potential benefits, avoiding probate, protecting assets, ensuring a smooth inheritance, vanished the moment they failed to fund it. When you change ownership to a trust, you have to transfer assets into the trust, and you're changing the legal ownership. You can still use them, but the trust/trustee will own them legally. So double check your list of assets to be certain that you have moved them into your trust. Ensuring that your trust is properly funded will provide you with the protection you seek and the peace of mind that your affairs are in order. Please like, subscribe, and share this video. See you next time. This is The Business Guy.